Well, good morning. This is Jagender Rana. The topic for the discussion today is spontaneous combustion loss. Spontaneous combustion loss. See, spontaneous combustion is a nitpicky issue in fire insurance. It's a matter of great concern for industries that deal with substances that are prone to spontaneous combustions like haystacks and unprocessed cotton may self-ignite because of heat produced by bacterial fermentation. Grain dust in a hot metal silo can explode violently, destroying the structure. Boiled linseed oil in a partially confined space, such as a pile of oil-soaked rags left out in an uncovered container, can evaporate, leading to a buildup of heat and thus ignition. Coal can spontaneously ignite when exposure to oxygen causes it to react and heat up when there is insufficient ventilation for cooling. Pistachio nuts are highly flammable when stored in large quantities and are prone to self-heating and spontaneous combustion. People have also been reported as spontaneously combusting. However, the effect is largely attributed to the wick effect, whereby an external source of fire ignites nearby flammable materials and human fat. So the process of spontaneous combustion starts in a small portion with the absorption of oxygen from the air by the community, resulting in oxidation of and the consequent increase in temperature, and eventually this process of heating is accelerated and affects the other parts of the stock in the same heap or stock. So at this stage there is no ignition, and if detected it will be found that the commodity after being heated up changes its color and original quality. So since there is no ignition, the claim does not fall in the scope of the cover. However, the built-up heat in commodity can result in actual ignition of the commodity. So the operative clause of the fire policy excludes damages caused to the insured property by its own fermentation, natural heating, or spontaneous combustion. The word "its own" in the exclusion term puts this claim out of the scope for admission of liability, but it is important that this exclusion applies to the originating fire only, and if fire spreads to the other heaps or stocks, the subsequent fire damage on those heaps or stocks damaged by fire is the liability of the insurers. However, to take care of the communities where such risk is inherent or where the property has a tendency towards self-heating, like coal, vegetables and cakes, so groundnuts, etc., the insurers provide add-on cover to the basic fire package cover. This extra cover is, however, made available by the insurers to include loss or damage by fire only, or or to the property insured caused by its own fermentation, natural heating, or spontaneous combustion. Thus, the additional cover is only for the fire damage as a result of spontaneous combustion. Now, fire and combustions are very important terms to deal with the losses, where real or dominant cause of loss is spontaneous combustion. So, the meaning of fire plays an important role in fire policy, which is not a simply fire cover, but a package policy covering various perils including fire. So the term fire has not been defined in the fire policy, but this term is understood in its ordinary popular meaning as established in various legal decisions that defines insured fire as actual ignition or burning of property which is not or ought not to be on fire, and that is under accidental or fortuitous circumstances. So absence of definition has also created situation where this term has been put to legal test in court of law. So fire is the form of heat energy which causes smoldering, burning, heating, melting, and perhaps few more words. But in insurance context, fire is associated with the flames or actual ignition. So combustion is defined as the burning of any substance, whether it is gaseous, liquid, or solid. So in combustion, a fuel is oxidized, evolving heat, and often lights. So the combustion of solids such as coal and wood occurs in stages. First, volatile matter is driven out of the solid by thermal decomposition of fuel and burns in air. At usual combustion temperature, the burning of the hot solid residue is controlled by the rate at which oxygen of the air diffuses to its surface. It is also known that some materials can combust spontaneously. And writers have a point that this is because of the natural behavior of the goods, and in standard fire cover, this is an excluded peril. So to understand it better, we would know how a spontaneous combustion occurs. A substance with a relatively low ignition temperature begins to release heat, which may occur in several ways, such as oxidation or fermentation. So the heat is unable to escape and the temperature of the material rises. So the temperature of the material rises above its ignition point. Then combustion begins if sufficient oxygen is present. Though such losses are excluded in standard fire policy, but as discussed above, protection against such risk is available as an extra add-on cover that is available on additional premium along with the normal cover. So this looks simple and clear, but in practical situation, the parties to contract may encounter several problems in dealing with losses, especially related to spontaneous combustion. So the issue that may surface once losses related to spontaneous combustion are reported, whether it's a standard fire cover or the endorsement for spontaneous combustion is attached to the basic cover, whether the loss is due to spontaneous combustion only without ignition or flame, whether coverage for spontaneous combustion is excluded if there is no flame or fire, whether it is possible to segregate pre-ignition and post-ignition losses, whether such bifurcation is relevant even when endorsement for spontaneous cover is available, whether subsequent fire to other parts of property including heaps different from the heap where the spontaneous combustion place is covered in the basic cover, whether fire covers only when there is ignition and whether spontaneous fermentation or heating without ignition is not a fire in terms of the cover, whether it is insured or the insurer who has the burden of proving that such loss is admissible or not. Once the insurer realizes that the loss falls in the exclusion clause of the cover. If it is only the basic fire cover, there may not arise any complication as the policy has a very specific exclusion mentioning that it covers fire losses excluding destruction or damage caused to the property insured by its own fermentation, natural heating or spontaneous combustion, or its undergoing any heating or drying process. Now fire occurs only when there is ignition, and spontaneous combustion without ignition is not termed as fire as per the terms of the cover. So since the standard fire policy excludes the loss due to spontaneous combustion, there is no issue when underwriters do not admit the liability for a spontaneous combustion loss. In fact, the spontaneous combustion, when resulting from an internal oxidation process through the chemical action of its own element, and when there is no resultant fire contributing to such a loss, then it falls in the excluded peril clause of the policy. However, the built-up heat generated by the oxidation initiates the flame or ignites then such fire that spreads to any other insured property and causes loss to such insured property is well within the scope of the fire policy, and such extended loss caused by such fire is covered in the policy. So if the insured has purchased an add-on cover on the basic coverage, then a slip is attached to the policy providing that in consideration of the payment of rupees such and such by the insured and company of the additional premium, the company agrees, notwithstanding what is stated in the printed exclusions of the policy, shall extend to include loss or damage by fire only of or to the property insured caused by its own fermentation, natural heating, or spontaneous combustion. Now, with this endorsement, the spontaneous cover peril is insured for the issue that surface at the time of claim is whether fire or actual ignition is a precondition to admit the loss to product due to spontaneous combustion. Now, underwriter's contention in this regard is that as per this slip, for a loss due to spontaneous combustion to be admitted as insurance liability, there should be actual ignition, and if there is no fire with flames, insurers do not accept it as liability as per the contract. But there is another school of thought which feels that once additional premium has been charged for covering the risk of spontaneous combustion, then fire only word is elusive, since the basic policy would normally cover loss by fire by any means, maybe spontaneous combustion or accidental ignition. So if the intention of insurer is to cover only the loss or damage by fire, they should not have charged any additional premium. And was the exception of loss due to the peril of spontaneous delay deleted by additional premium, there should be no denial whether there is a actual ignition or not. So there should be no question regarding the pre-ignition or post-ignition losses. When there is a difference in expectations and understanding of the same cover, it creates a ground for litigation, and such a dispute may not get resolved by common sense words but would require the legal interpretation to define it. So the dispute arising from the issue that actual ignition is a precondition to admit the liability of claim arising from spontaneous combustion has been put to its legal test by some parties by invoking the matter to the National Consumer Dispute Redressal Commission, as can be seen in the case of Roshanlal Oil Mill versus United India, Saraya Sugar Mill Limited versus United India, and Murli Agro Products Limited versus Oriental Insurance Company Limited. So in Roshanlal Oil Mill case, the Commission observed that if it was the intention of the insurer to exclude the damage by spontaneous combustion in pre-ignition stage, this ought to have been stated much more clearly and directly. The Commission felt that the language used in the insurance policy is unqualified, and the rejection in their opinion was not justified in terms of the insurance policy. So the Commission pointed out that it is a settled law that contract of insurance is based upon good faith, and it is the duty of insurers and their agents to disclose all material facts within their knowledge, since obligation of good faith equally applies to them with the assured. MKJ Corporation versus United India was referred to in this reference. So Commission categorically mentioned that if the insurance coverage was not extended, even by taking additional premium for the damage caused by spontaneous combustion or natural heating, which may not result in fire, it ought to have been stated clearly. Finally, the Commission also stated in its order that it is high time for the insurance company to have terms clearly defined in the insurance policy with a reasonable clarity, and not to continue with the old forms which terms are vague. So insurers submitted before the Honorable Commission that even though there was a spontaneous combustion, but as no fire has occurred, the insurance company is not liable, since the endorsement is specifically stated that the policy shall extend to include loss or damage by fire only or to the property insured caused by its own fermentation, natural heating, or a spontaneous combustion. So the London Commission in Roshanlal Oil Mill order dated 14/5/2008, original 14th May 2008, original petition number 89 of 1991 also observed that identical contention has been negativated in the case of OP number 253 of 99. So the general insurance market today is open, competitive, and receptive to the needs of the clients. The underwriters have now changed the wordings of the spontaneous cover, and this endorsement has now divorced the word fire only from its wordings. This now makes the cover clear, concise, and effective. Thank you.